Hi everyone. In this lecture we're going to talk about the legal dilemmas that are discussed in your book. When we talk about legal dilemmas, we're talking about is a dilemma. If you see the scales there on this slide, you have a balance that you're trying to achieve in the justice system. And when you enact statute or change laws, you're having to make certain decisions about how to achieve that balance. So the dilemmas then are a choice between two opposing moralities. Both sides are correct. Both moralities are correct. Both are valued by society. And anytime you make a decision, you're kind of tilting the scale one way or the other, and this causes tension. So what you do then is these laws, as they're passed, might take this scale and tip it a little bit further down here while this one goes up. So it causes some kind of tension. In the jurisprudence area, this is a part of philosophy that studies law. They look at these legal dilemmas and they will often do a formal analysis of where a society is going. So that is called a dialectical analysis. If you were to do a dialectical analysis, you would probably look at some important information and try to determine which way a society is going. So for example, if I was going to write a paper, I might look at all the Supreme Court decisions that have been made during the past 10 years to see which way this country is going in terms of these four different dilemmas. But we're not going to be doing any formal dialectical analysis, but in your discussion this week, you're going to be asked to bring up some recent laws or things that you know of and discuss with others about whether and which one of the opposing moralities is getting pushed here and what is the tension and whether or not you agree with it. So you're going to be doing your own informal dialectical analyses in your discussions this week. Well, let's just get started and find out what those four dilemmas are. The first dilemma is the right of the individual versus the common good. This is probably one of the more important dilemmas that we face in our society. We know in this country individuals have rights, and the laws ensure that you get to have those rights. In fact, it's kind of the cornerstone of our society. People call us pretty individualistic. We believe in free speech, freedom to pray to whomever you want, freedom against unreasonable search and seizure. We've got a lot of individual rights. But society also has expectations. Society has a right to ensure that you meet the expectations that it's put forth. So, for example, you can't do things that infringe on the liberties of others. That's why, stealing is wrong. Sure, you don't have money and you need the money, so you take it from someone else, but you're actually hurting someone else's liberty. And if you think about it, there are lots of issues in this country that involve individual rights versus the common good. And they can cause tension whenever you talk about infringing on people's rights to bear arms. You get arguments about you're infringing on individual rights, whereas society might say, well, yeah, but we're trying to ensure the common good. So you're going to have tension here. There are some great debates that basically match the rights of the individual versus the right of the common good. And you can see many laws that may have been passed that tip the pendulum one way or the other. Some of you may live in communities that have grappled with whether or not you would allow smoking in public areas. Think about how that argument plays out. Okay? So if we were going to do a formal dialectic analysis, what we might do, like I said before, is you would do a formal study and write up a paper. So you might look at Supreme Court decisions during the last 15 years. Which way are they tilting? Are they tilting more to the individual right or to the common good? And then you might write a paper and talking about how our country is shifting from one to the other. You might analyze state laws that have been passed and determine to what extent it's the individual versus the common good. You also might examine things like our criminal justice system itself. you know that within the criminal justice system, there's two sort of opposing modalities here. One is crime control, which is society has the right to be safe, and so when you're in a crime control model, we want to keep the community safe, which is the common good. Then we'll be more punitive with people who break the law. We'll give them longer sentences, and so forth and so on. Due process, on the other hand, is really focused on the rights of an individual accused of a crime. And we might look at laws to see whether or not we're passing more laws to give defendants more rights. And if you were going to do a formal dialectical analysis, I'm not quite sure what you would come up with, but certainly you would see this conflict, the individual rights versus the common good, come into play. The next morality or dilemma is equality versus discretion. Obviously, on the one side, we believe that we are all created equal. We should be all treated equally. The laws shouldn't ensure special treatment. We should all have the right to the same privileges that everyone else has. On the other hand, society also values discretion, such that when someone commits a crime and we find out that they have a mental illness, we may not want to treat them the same way as we treat somebody who does not have a mental illness. And you can see that there are many things in our society that sort of touch on equality versus discretion. The gay marriage, the decision to allow people of same sexes to marry is certainly one that hit on equality versus discretion. There were some that felt that marriage should be defined one way, so discretion, versus another group that said, no, if marriage is the law of the land, everyone should be allowed to be married. So again, you can see how these dilemmas play out in real life, in real time. And I think you'll probably find that when you start to think about it, many of the laws recent laws that have been passed hit on equality versus discretion. The third dilemma is discovering truth or resolving conflict. If you think about it, what is the ultimate goal of the legal system? Is it in finding the truth, or is it in resolving conflict? You know, when you allow somebody or give somebody a plea bargain where you're not going to charge them with first-degree murder, but give them manslaughter, and they have a less punishment, is that discovering the truth or resolving a conflict? So think about it, and think about the many different ways in which we either tilt towards the truth or tilt towards, let's just get this conflict resolved and moved on. Okay, so that is the third dilemma. Finally, the last dilemma is science versus law as a source of decisions. When you think about it, science and law are very different in the way decisions get made. In science, it's empirical testing that leads to the truth. So it's research, it's collecting data, it's doing studies, and when you do that, you will find out what the truth is. Of course, I put truth in quotes because it's hard to find the absolute truth. In law, however, it's a very different philosophy. In law, the truth is based on case law. So if in order to find the truth or to find how you should decide a particular case, you look at past cases. So you don't do an experiment to see what's the right answer. You look at other cases that were similar to yours, look at the decision they made, and you make the same decision. And this policy, or it is captured in this thing called stare decisis. And this is a very important part of law. What stare decisis means is that it means let the decision stand, which means let's not change radically. Look at the past decision to guide your current decision. What this means too is that the legal system sometimes can move really slowly in changing things. I mentioned last time that the legal system still refers to intellectual disabilities as mental retardation. And they still, you'll see in legal writings, they'll use, was the defendant mentally retarded? Which is something that in psychology we don't use those terms anymore. But the fact of the matter is the law is very slow to change. Just to give you an example, if you look at, let's take as an example, let's look at the changes in the court's views on separate but equal facilities for African Americans. Just as an example to show you how slowly the ship turns. I sometimes liken law to a huge cruise ship, and you're not going to be able to turn it very fast. It's not a speedboat, let me tell you. So let's take a look at separate but equal and how long it took the courts to kind of come around on that particular issue. So, separate but equal. We start in 1896 with Plessy versus Ferguson. So Plessy was mostly of Caucasian ancestry, but he had one Negro and I'm using the term Negro because that is the term that was used at that time, one Negro great-grandparent, which according to the law made him colored. Okay, so Plessy was riding in a train, and he was in the white section, and he refused to move to a different car. And of course he was arrested, and he took his argument to court. The courts, the New Orleans court and later the Supreme Court, did not agree with Plessy's argument that segregated railroads violated his Fourth Amendment right to equal protection under the law. The Supreme Court said that separating the races did not imply that one was inferior. Okay. In fact, here's the court's argument. They failed to see Plessy's argument that enforced separation of the two races, that separation of the two races stamps the colored race with the badge of inferiority. If this be so, it is not the reason of anything found in the act, but solely because the colored race chooses to put that construction on it. And that's where we got separate but equal, the separate but equal doctrine. And the court is saying, if you think it's unequal, it's only because you perceive it that way. It's not true. So we had separate but equal doctrine in 1896. How long did it take to break the separate but equal doctrine? Well, there was not one single budge for many, many years until Sweatt versus Painter. In this particular case, Herman Sweatt was an African-American man who wanted to enroll in the University of Texas Austin's law school. But the problem was Austin was an all-white law school, and the law school for African Americans was in Houston. So Sweatt took this particular case to court because he felt he should be able to be in Austin. This time, the Supreme Court ruled in favor of Sweatt. But it was very interesting how their decision stood. What they said was, it wasn't separate but equal that was wrong. It turns out what they said was Austin wasn't equal to Houston. They said the libraries were better at Austin, the facilities at Austin were better, and so they basically said, if it's separate but unequal, we can rule against it. So that was just a little crack, a crack in the armor there, was Sweatt versus Painter. And it was 4 years later that the Supreme Court broke it open altogether. And that was Brown versus the Board of Education in 1954. Interestingly, that Supreme Court finally decided that the separate but equal was not true, that there were negative psychological effects associated with segregation that were inevitable. And in fact, it was interesting that in this particular case, it was an amicus brief that kind of convinced the court that separate but equal wasn't true. And so I'd like to share with you, because this particular amicus brief was filed by psychologists, and it was included a study that was done by Kenneth and Mamie Clark. Kenneth and Mamie Clark were social psychologists. There they are pictured there. And what they did was they provided some information about their research. And in particular, this was a doll study. What they did was they compared the doll preferences of 253 black nursery school and elementary school children. So let me just share with you what they presented to the court. So in their research, they had a black doll, and a white doll, and they asked children, give me the doll you like to play with best. And of course, I'm presenting their data just exactly as they did. They're referring to African American children as colored and white as white. And they separated the children who are living in the North and children who are living in the South. And that separation is interesting, but it's not really our main point here. But so give me the doll you like to play with best. And what you found is that African American children in the North and the South overwhelmingly chose the white doll to play with. Okay, so this is their data here. Give me the doll you'd like to play with best. Give me the nice doll. That's what some other children were asked. You see in the South, still saying the nice doll is the white doll. In the North, the white doll was the nice doll. Okay. Give me the doll that looks bad. Okay, so which one is the bad doll? The one that is yucky. And overwhelmingly, the children chose the colored doll. The interesting thing about this particular study is the Supreme Court found this pretty shocking. And they quoted some of this research in their decisions. So we actually broke separate but equal with a study conducted by 2 African Americans, which basically showed that children, black children, didn't like black dolls. And the court decided that it was psychologically harmful to children to keep them segregated. And I have to tell you, I wholeheartedly agree with their decision, but I have an alternative explanation for these results. Can any of you think of what was going on? What might have, is it the segregation that caused children to choose white dolls over black dolls? Or is it something else? If you really think about it, how many children, how many African American children in that study in the 1950s would have ever seen a colored doll? All of the dolls that they were playing with were what? What color were they? They were white. And maybe some of the children in the study, when they saw the white dolls, they saw familiar dolls. But those color dolls were strange. Regardless, I'm really happy that the Supreme Court decided that separate but equal was not correct anymore, even if they used a study that maybe could have been subject to alternative conclusions. In any event, we've now covered the 4 dilemmas, and in your discussions this week, what I want you to do is look around you, read the paper, think about laws that have been passed, and discuss on the discussion site what you've come up with, which dilemmas it fits, and whether you feel that it's going in the right direction or is it going too far in the wrong direction. So for example, we all believe in the common good and we all believe in individual rights, but we vary in terms of which one is more important to us. So in your discussion, I want you to include some of that information. And again, remember to be respectful to everyone. It's our opinion, and because both sides of the morality are right, that means we're all right. Okay, see you next time. Thank you. Bye.